into the story now. The Cabinet has welcomed the company's amendment bill, which was published on Friday. So the bill is expected to show transparency between the lowest and highest paid employees. Professor Michael Katz is a company law expert. He's part of the specialist committee that developed the bill. He joins us now to give us more insight on that one. Prof, thank you so much for your time this evening. What does this bill seek to do?
Okay, good evening, both. Thanks for the invitation. Well, the bill has three primary philosophical pillars. One is the ease of doing business. Secondly, transparency in remuneration. And thirdly, combating money laundering and terrorism. Those are the three primary objectives of the bill, but there are some pure technical curing defects that have manifested in practice since the bill was implemented on the 1st of May 2011, and all of this has been done in accordance with international best practice.
So in terms of how this will then be implemented, does that mean that employees will be able to know their salaries of their employers? Well, at least when it comes to listed companies as well as state-owned enterprises?
Yeah. What the objective here, and let's see the philosophical reason. Inequality in society is a concern worldwide, and that has been accentuated even more so in a post-COVID world. And one of the factors that worldwide is being attributed to this inequality in society is excessive remuneration, particularly at the top. So what the bill does, and it's really important to emphasize, the bill is not prescriptive. It doesn't tell companies what they can and can't pay. It's based on a philosophy of disclosure. So there will be a remuneration policy report, a remuneration implementation report, and there will be disclosure of the average payments of the top 5% in a company of employees, the bottom 5 and the median. And that will then inform proper public discourse and enable shareholders to decide whether or not to approve the remuneration report. But I can't sufficiently emphasize it's not prescriptive, it's disclosure.
Yeah, so if it's not prescriptive, Prof, just help us understand then, if it's not prescriptive, can then companies simply choose to avoid it? And can they interpret the bill according to their own agenda and their own will?
I think when I say it's not prescriptive, how much a company pays the employees isn't prescriptive. What is required now in terms, if the bill becomes law, companies are obliged to disclose what's paid to the directors and prescribed officers, and then there's a remuneration policy and a remuneration implementation report. These must be disclosed to shareholders, and it must disclose with precision. There's just one debate between Labour and business at the moment. The average remuneration paid to the top 5%, the average remuneration paid to the lowest 5%, and the median. Now, the only debate at the moment in the consultations to date between business and Labour, in the pay gap, business says to avoid once-off bonuses on that, the average should be calculated to avoid those distortions. Labour's view is that it should be the actual remuneration. And business says the remuneration report should be approved by an ordinary resolution, that's 50 plus 1. Labour says it should be approved by a special resolution, which is 75%.
Sure. So in this case, I mean, from what we understand, is it targeting publicly listed companies and state-owned enterprises? And if it's just those publicly listed companies and state-owned enterprises, we've got a whole lot of businesses in the private sector which actually may experience that inequality on a day-to-day basis, who will never know in terms of how much a director gets paid versus how much the lowest paid employee gets paid simply because of their status.
It's not only listed companies, it's public companies, state-owned enterprises, and private companies whose public interest score exceeds a certain level. The public interest score is based on turnover, based on number of employees, various things. So the Act, in a number of contexts, prescribes for public companies, state-owned and private companies having a public interest score in excess of a certain amount determined in the regulations.
Yeah. And then in this case, obviously, it's around showing, being able to show and track those that are highest earning, those are within the middle, and of course, those are the lowest earnings. Any recommendations that happen subsequently? So let's take, for example, if company X, right, has got directors that are earning exorbitantly versus the ones that are, lowest earning. If they present those figures and they present those numbers, so as to say, as per this bill would recommend or say, then is there any form of recourse? Can they decide to do something about it? Or is that purely on at the discretion of the company? This company can simply go, here are what our numbers look like, take it or leave it.
That's a good question. What happens is it's disclosed in the remuneration policy and the remuneration implementation report. That comes to shareholders for approval. The company can't pay other than in accordance with an approved remuneration policy. And if it's not approved, then there's certain procedural requirements. There must be further negotiations, further discussions, and it must come back to shareholders for approval. So there are sanctions for paying other than in accordance with a remuneration policy approved by shareholders.
Prof, then in light of this conversation, how can employees exercise their voices more and be more vocal when it comes to this bill?
Well, the bill is now going to be, it was gazetted on Friday, and there is a period of 30 days for public representations to be made to DTI to take cognizance of the views of stakeholders, the public, workers, anyone. Thereafter, the department, the ministry will decide what to do, and it will take it to the cabinet. And if the cabinet approves it, it will go through the parliamentary process. And there again, there's going to be opportunity before the portfolio committee for the public to make further representations.
Professor Michael Katz, we'll leave it there for this evening. Thank you so much for your time and just giving us a little bit more insight about the draft bill proposing that companies, by the way, as well as state-owned enterprises, disclose the pay gaps between directors and workers. Interesting times that we're heading to in South Africa. Still ahead for you.